do that. And as a litigator and a judge, I'd be interested in your response to that. And then the second thing, and
that's very dangerous territory, because you always have disagreement. You always have shades and permutations of all of these things, where one sees it one way and one sees it another. One hears evidence and it is not the way the other hearer has gotten it. And so examination is, generally speaking, the best place to start. Look at it and see what there is that is different, and see whether it was properly handled as a judge.
I would say, in addition to that, and I agree with that, I think different judges are going to see things differently. But equally important is the fact that each of these cases is unique. The facts that are presented to Judge Kennedy in Case A are different than the facts that are presented to Judge Kennedy in Case B, or to Judge Leon in Case C. And so I would be a little skeptical of those who say, well, different judges are coming up with different answers in the same context, because I think the context is very different for each of these cases. And my experience and observation in reading the opinions from the judges who have decided these cases so far is that the judges consider the full array of evidence that's been presented. They don't just focus on this piece of evidence, but they consider all of the pieces of evidence as they would in a normal trial, and they make their decision based upon all of that evidence. So even in cases where you might have 4 pieces of evidence that are the same, you're likely to have 6 others that are different. And so you might find a different decision in cases where someone was arrested at a guest house in Pakistan, and then someone else was arrested at the same guest house. But what you'll find is different is what they did before they got to the guest house. And I think that's significant. And then the final point that I would make is that in part, it is the function of the Court of Appeals to make sure that if a judge gets it wrong, particularly if a judge gets it wrong with respect to the law and the legal significance of a fact that's found, for example, the Court of Appeals is there to fix it, and I think in some respects to potentially ensure a greater level of consistency.
Is the sister proud of the answer? It's a tough row to hoe, because there is what I said exists in the beginning, and what is important is that we have transparency. You can hear all this stuff, and you can see how it's examined, and you can use your journalistic expertise to parse it and go through it, and to criticize it, and to do all the things that you do so well.
The one thing, just a little caveat on that, is that...
Well, I take it all back, Doug.
Well, the trials of these cases are generally not open.
That's correct.
And many of the proceedings that involve classified information are proceedings that are closed. And what we've observed is that most of the judges will have an unclassified session at the very beginning, where there's an unclassified opening statement made by both sides, and that is open to the public. But then the court goes into a classified session, and only people who are involved in the case and have appropriate security clearances are allowed to remain for that portion of the trial. At the end of the case, the judge, in all of the cases so far, has issued an opinion. And in most of the cases, the opinion is classified. But then what happens is a redacted version of the classified opinion is released within a few days later. And the transparency that Judge Sessions is talking about, I think, really does come to the fore when you're able to look at the unclassified opinion and really get a flavor for why it is that Judge Kennedy decided this case the way Judge Kennedy decided it, or Judge Bates or Judge Leon or whoever it is.
Okay, with that, we come to, as we say, the end of this event. And thank you very much for attending. And see you all again soon.
Great.
Thank you.
Thank you.
You
Pleasure.
You spoke about the honor of it. It was an honor to work with you.
No.
And you've been in the field where it's done. What they say about courts of appeals.